Good morning. Welcome. I'm Lori Berman. I'm Vice President of Membership and Development for the Small Business Association of Michigan. Welcome to today's webinar, Understanding HR Issues Related to the CARES Act and Michigan Executive Orders. Thank you so much to Raymond and Susan West for being a part of this today. Those of you that were online last week may remember that Susan helped us out in the tax one that we did last week as it relates to all these things. So thank you for being here. This is a part of a series we've been doing. This webinar will be recorded and posted online along with the slides. And I will send a link out to all of you participating today as well, so you can go back and refer to it again or share it with others. Wanted to mention also that we do have another webinar next week. It's on Thursday, and that one is about the state, the Michigan Supplier Connection, the Michigan Supplier Database for small businesses. If you're interested in doing more small business, doing business with the state, it'll be a great webinar for you to take advantage of. That is on Thursday at 2 p.m. and you'll find information about that on our website. Without further ado, let me introduce to you Susan West. Susan is an SPHR. She's a SHARM SCP and Principal of Human Resource Solutions for Raymond at their Troy office. Her service areas are human resource consulting and outsourcing, leadership coaching and training, and strategic planning. With a passion for uplifting human resource functions and leadership talent in small to mid-sized companies, Susan focuses on providing the expertise and guidance for addressing and improving HR business performance for clients. Susan and I were talking as we started this call that everything changing is like drinking from a fire hose lately. We know that it's changing rapidly, and many of the things are not all fully outlined yet. So we appreciate you being here, Susan, today and sharing your information with our members. For those of you that have questions, you may use the question and answer feature that is on the webinar, and we'll get to your questions at the end today. I just ask that you keep your questions focused on the HR issues. If you have other questions about loans, those type of things, please send those to sbam@sbam.org. That's sbam@sbam.org. All right, Susan, I'm going to give it over to you.
Perfect. Thank you, Lori. Well, welcome everybody. I'm glad to be back. And I appreciate that Lori just said, keep it focused on more of the HR, because as we expand out to the loans and the tax credits, I mean, we have other experts in that arena. So let's go ahead and begin. I'm going to do a bit of a brief overview. We know that we had the Families First, and we've talked about that. Then we had the CARES Act come into play and all the impacts that that has had. We also know that the Paycheck Protection Program is now being funded. So a lot of our employers are receiving those funds and planning a return to work. One of the things we talked early on is what are the workforce strategies that we're all considering as we're looking at initially, what did we do when we had the shutdown orders? And now we've had people who have been laid off if we were a non-essential service. And so now we're considering bringing them back because we have the Paycheck Protection Funds. So as we look at what are all the things we can consider, we've talked about everything from a layoff, which could be considered more of that permanent layoff, versus a furlough or temporary leave, two different kinds of things. We've had voluntary leaves of absence, where a lot of companies might have had policies that allowed employees to actually choose a sabbatical, which would be a 3-month potential leave of absence. And then we've had true termination. So the fact that we unfortunately may have employees who are violating policy or having performance issues, those typical kinds of terminations that we may incur as an employer and as an employee are still ongoing. We have the remote workforce, teleworking, telecommuting, those discussions and options that we're looking at with all of our workforces. And then we've had the work share program that many state unemployment agencies are offering. I know Michigan has had one for a long time. They actually have just released some new guidance on that may actually make that a little bit more workable for clients when initially when the whole program opened, that may not have been a good fit for clients. So we're really looking at how do we balance the needs of the employee and our client if we're customer facing. How do we keep them protected and the well-being in mind, along with making sure that our business is viable and surviving? So a lot of very difficult business decisions being made. When we look at the Emergency Family Medical Leave Act, up until April 1, it was just something out there in play. From April 1st, we've now had to actually implement this, and we have those who have essential workforces and are working have already had to start to implement this. We also have the well, some of the details, just as a reminder that the emergency medical leave had one qualifying reason. It also defined how the pay could be used for the first 2 weeks, could be unpaid, could be supplemented with paid sick leave if it was a qualifying reason, and or could be unpaid, or use your company's PTO or other paid leave criteria. So how it's all paid is something that you have a discussion with the employees and really begin to document what were the determinations there. We're going to talk a little bit about this later in terms of policies and forms and documentation. And then there's some clarity on how this this particular Emergency Medical Leave Act should in fact be paid out. And then how do we actually, as the employer, get the credit? Those credits should be coming into play here at the end of the second quarter. And then we have the Emergency Paid Sick Leave Act, for which we know there's 6 qualifying reasons for 80 hours of sick leave. Again, some details around how this plays out, when employees are eligible from day 1 of work, who's covered, and then the fact that there could be some potential exemptions as a small business. So definitely taking a look at that if you are concerned about your the viability of your business and looking at those exemptions. Again, some details on how the wages are paid, what is paid in terms of the reason, to only 2/3 for the reasons, qualifying reasons 4, 5, and 6, 100% of the wages for 1, 2, and 3. The number of hours is driven by the work schedule, so part-time employees are also eligible. So I know we've gone over this kind of detail previously. I think a lot of us are familiar with these, but now how do we actually employ them or put them into practice is more of where the focus is today. Then we had the unemployment provisions come out under the CARES Act. So we had the federal pandemic unemployment comp, which has created a lot of discussion, a lot of concern, a lot of happiness for some of our employees that are actually finding this as a positive benefit for them right now, where they're getting that extra $600 in benefits as a flat amount. We had the pandemic emergency unemployment comp, which extends the availability of unemployment for an additional 13 weeks. And then we had the pandemic unemployment assistance, which broadened the category to a whole new class of workers that included independent contractors and the self-employed. We know that they were able to get on the systems April 6th. Most of the states we're able to get their systems updated so that those folks can apply. This timeline is sort of the one that I think helps start to put it in perspective. And I think it's where it shows when things are effective versus when they were actually went into law. And so, for example, the Family First Act was passed on March 18th, and it's actually effective April 1 through December 31st. We're past that non-enforcement period, so that means we should be fully utilizing it. We should have our posters up. All the kinds of things that you need to have in place should now be in place. We're past what we call that non-enforcement period that the DOL provided. Then we had the CARES Paycheck Protection Program show up, if you will, and people were starting to apply around April 6th. They're already starting to receive their funds. And this is a period where here in orange, you can see we're now where we might have made decisions to lay people off here, that we're now actually looking at returning those employees to work so that we can get the full forgiveness of our paycheck payroll payments to employees that were returning to work through the 8-week period that follows the awarding of the loan. We then have these 3 different unemployment laws that are also impacting us. So one of the biggest things is that the $600 is actually good between April 6th through July 31st. If a person is eligible for a state benefit amount, weekly benefit amount, then there's actually the opportunity to earn that $600 flat payment. What we know is that the CARES Act actually expanded it for the 10 additional reasons. Again, I think this is creating some confusion on the part of employees and employers as to whether or not they're qualified for the unemployment. And I know I've had several conversations with clients to say, okay, what does this mean? Especially when we look at number 9 there, quit their job as a direct result of COVID-19. Well, we know that we've seen some guidance from the DOL and further guidance from a lot of the state unemployment agencies that the whole intention is that employees work when they have the opportunity to work. Quitting without good cause to obtain unemployment insurance benefits has been defined and claimed that it could be fraud under the Pandemic Unemployment Assistance Program and may result in disqualification for benefits and obligations to pay. So I know that a lot of folks are trying to decide if, in fact, if we have people laid off, they're not qualified, or under one of these reasons, they say that they're not qualified to come back to work, but we have work to offer. They're going to quit. They quit when they have work available. What does the employer do? How do we educate the employees? It's just a little messy. And one of the biggest things I'm advocating is that there be those communications one-to-one on the particular circumstance with the employee and an employer to fully understand what the responsibilities are on both sides. What we do know is that if you're eligible for $1 under the weekly benefit amount at the state level, you will get the full $600. If you're not eligible for the weekly benefit amount, then you will not get the $600 in federal dollars. What we're finding is because this has been a long, long time, some of these employees have never, ever had to apply for unemployment, a very good thing. But now we have millions, 26 million across the nation that are applying for unemployment. They are applying with a reason that is incorrect. based on how the employer may have let them go. And so what's happening is employees are receiving notices for which they say that they're not eligible for unemployment or they need additional information. And that's causing employers to have to respond then to what's called the Form 1575s that provide additional information, or the employee needs to go back into the unemployment system and keep track of what is the status of their claim because they're waiting on more information. What we know is that doing your communication, at least in Michigan, between the hours of 8 p.m. and 8 a.m. Online may allow you an opportunity to get a response more quickly. We also know that you may have to work to get the proper reason in for why the employee was actually on layoff due to COVID-19 related reasons. Employers do have the opportunity to go into the system and actually apply on behalf of the employees. In Michigan, it's not a requirement. In some states, it is. So for example, Georgia is actually requiring that the employers go in and apply for the employee. Getting online with your MyWAM account is critical right now. I know a lot of you have not gone in and actually registered for your online account, or you can't remember who signed up in the very beginning. If you get that cleaned up so you can have access, it's a huge benefit, because there is an opportunity for you to actually communicate directly online and respond to the kinds of notices that the employers are sending to you. So it's important that the employers are being responsive to the notices they may be receiving in the mail or the online accounts for MyWAM. What we also know is that employers are going to have to be vigilant in terms of really declaring what is the status of that employee. So did the employee actually have a valid reason for a temporary shutdown due to COVID-related reasons? Or in fact, did you have an opportunity for them to work, whether it was on-site or a remote work situation? And in those two cases, then you really do need to be clear and respond in a way that contests a claim that an employee had an opportunity to work. Now remember, if the employee has an opportunity to work and is already working with you and then has a claim against one of the leave options, paid sick leave or FMLA, they were in a working status and now they're qualified for one of those reasons, then they would be considered eligible for those payments. It would not be eligible for unemployment. So it's an interesting distinction, and we as an employers have the responsibility to really understand at what point is a leave option and payment available, and at what point is the employee eligible to work and or then not eligible for unemployment, and actually making sure that we're claiming that at the time you're responding to an unemployment claim. So with all of this said, we're sort of at this crossroads here where, you know, what the heck do we do? We have employees that are laid off, especially those of us that were in non-essential services. We've gotten our loan funds, and how do we make our decisions around whether or not we bring them back? We also have the stay-at-home orders. Are they going to be lifted? When are they going to be lifted? I know here in Michigan, I haven't caught up yet today, but I believe there was an intention that Governor Whitmer was indicating she was going to continue to extend that. So now, folks, that begins to play into when do we begin to return our employees? Well, what we have now, we've decided we're bringing our employees back to work and returning. So how the heck do we prepare for that? We have what I would call these 7 areas that we need to be looking at. And I would say this is, for those of you that are already working because you're essential, always sort of be continuing to revisit these areas even for yourselves. But then no matter when we are calling our employees back to work, how do we plan for that once the state orders are lifted? So the very first thing that all of us should be looking at is what's called our COVID Preparedness Response Plan. And I'm going to walk through each of these in a little bit more detail. But that's all about the safety. That's all about adhering to CDC guidelines, state orders, county orders. It's all about the well-being of our employees, clients, consumers. We have some compliance things. So very simply, are our labor notices up? Do we have our Family First notices and posters up? How are we making sure we're staying current with state and county orders and the additional kinds of requirements that they are posing? And how does that interplay with the things that maybe the CDC and or our particular industry demands? Then we have the return to work notices. What do they need to say? How do we educate and update our employees around all kinds of things, their benefits, their comp, their social distancing responsibilities? So there's a lot in that return to work notice that we're going to cover. We also have now a very big need. Again, some of us are already doing this because we've continued work. But for those of us that are returning to the workforce with employees who have been laid off, how do we really put in place our telework, flexible work arrangements? And then how do we begin handling the leave requests that are going to, my guess, are going to flood in? And then we have our compensation and benefit reinstatement, any adjustments we're making. We have to be clear about communicating around that. And then the last and 7th bullet point is, what communications are needed to keep our transparency going, to help our employees understand what it is we are doing to keep the business viable. We're looking at the longer term so that the business survives and we can continue to have us all engaged in valuable work. So if we take the very first one, the preparedness plan, I would recommend that you're seeing a lot of information come from your industries, your different associations, Small Business Association. What are some of the checklists that need to be in place? I know the CDC has a wonderful return to work guide that they have put out, Work for America, they've called it. Sorry. And they have a great outline. How do you begin to look at what are the things you need around social distancing? How do you train people? How do you handle meetings? All those details. Screening protocols. So what do you do at the time you have visitors coming in? Are you going to do a daily screen for your employees? Who's going to do it? What are you going to record? What personal protective equipment might you have available for your employees? Do you know if you have some sufficient amount? Do you have a plan to keep it stocked? Cleaning and disinfecting protocols. So what is it your employees can expect for cleaning and sanitizing the workplace? What about your safety communication plans in terms of if you have a COVID-19 positive episode or incident in the workplace, knowledge of how do you make sure that you're educating what the next steps are, providing the proper notices, taking the proper protocols then to put in place all of these and reinforce all of the 4 things above. And then as this whole COVID-19, both improvement in tests and the protocols around, oh gosh, I lost my vaccines, right? What is it we are going to do as an employer? What is our plan of action going to be? What are we going to require of our employees? What can we require of our employees? So I really encourage you to develop a checklist. There's a lot of great tools out there. I know we are helping our clients with those examples. And want to make sure that not only is there a communication guideline that you might provide to supervisors, what are their steps, where does HR get involved, and what communication do we have to have back and forth with employees who need to be educated on these practices. So the COVID preparedness response plan, having it written, having checklists around it, making sure those that are involved in making sure that we have the proper resources available for both cleaning and personal protection are all being recognized. So here are those, the model notices. Obviously, the one there on the left is generally the notice for the employee rights. The one on the right is for those that are federal employees. So depending on your organization, you would have those posted. One of the things I want to share with you around that, folks, is that we have seen where we have employees who have been concerned about coming back to work and have already restated their concern for doing so. They're asking questions around the Paid Michigan Leave Act. And I know that we, as many employers, have already included our discussions around that in terms of how it might fit into our vacation and PTO benefits already. So what we're finding, however, is employers are becoming much more savvy in terms of their knowledge of the law, whether they're getting some education on their own or they're getting some education from some legal guidance. We're also seeing that it's important that we have our other labor posters up, including the Paid Medical Leave Act. And then how do these things begin to interplay? So as we're looking forward around our policies, how do we make sure that we've declared and communicated to our employees how potentially the Paid Medical Leave Act interplays with the Family First leaves? And I see such a huge education for our employees to understand how we may have already incorporated that and have been compliant to the law by including it under our current vacation and PTO policies. So that's where some of the communication and education might come in, but making sure your model notices are up and available to employees both in the workplace and electronically. Now we have the whole complying with state and local orders. We know Oakland County has an order out there, Saginaw County, Bay County. They're all identifying some of the requirements and they're referencing one another, but they definitely interplay. So the order that came out on the state order 2020-57, actually, I believe just came out yesterday, and it has a further definition of what was 2020-24. So how do we begin to make sure that we're staying current on these things and understanding what's necessary to comply with? So for example, under this 2020-57, they have identified more, they being Governor Whitmer and her team, have identified more definition around some of the criteria for what's considered staying self-quarantined for a period of time. So for example, on this particular order, section 1A3, the individual has had contact in the last 14 days with someone with a confirmed diagnosis of COVID-19. Contact for the purposes of healthcare exposures is defined as follows. And so they're giving much more definition around being within approximately 6 feet, 2 meters of a person with COVID-19 for a prolonged period of time without appropriate personal protective equipment, consistent with the Department of Health and Human Services recommendations, or having unprotected direct contact with infectious secretions or excretions of the patient, for example, being coughed on, touching, using tissues with a bare hand. I bring this particular situation up because, once again, we've had employees who are looking to not return to work and are actually understanding these definitions of the law and bringing back to us the fact that they have had this kind of exposure. They're actually quoting the law or the order, and so therefore are saying, I can't return to work. So this is all this interplay that will allow us as the employer to have those conversations with the employee and make a decision. If you're returning to work, we want you to work, but now you're indicating you cannot work based on a particular state order. Are they really qualified for a paid sick leave? And what is the quarantine period that they in fact would be responsible for? So if they were exposed 7 days ago, they might still have 7 days of a return to work notice from you as the employer, and so would be off for another 7 days. I really encourage you folks just to take some time to understand these things. How do they interplay together? What is your response is going to be when you have these particular orders that are interplaying with both the CDC, the federal, state, and county? How does that flow into your particular policies and responses to employees who might come forward with a concern? So I actually spoke to you regarding the employee side, but as an employer, what are some of the things you're putting in place that need to go into practice at the employer's site? So back to your COVID preparedness response plan, have you also taken a look at the county orders and then state orders to make sure that you're addressing any compliance concerns that they want to see you take care of in the workplace? All right, so now we want to talk about return to work notices. So it's something that we actually recommend that you put in writing, just as we recommend you put the layoff notice in writing to the employee. This is all part of that documentation process that says you as the employer were very clear in your direction to the employee and that you're taking the time to communicate what the employee needs to know. So obviously one of the very first things is that, be well. We want you to feel safe. We want you to be protected. We want all of us to be healthy, thriving individuals, whether at work or at home. We want to talk about what happens around attendance. What is it around our time off policies? How are they coming into play? How is vacation, PTO, and leave requirements coming into play? Is there any hazard pay? Hazard, yay, that's what the employees say, hazard pay for those that you're asking to come into work. What's the criteria? How have you defined that? Return to work What is the date? What is the schedule? What are our expectations for that employee when they come back to the workplace? Um, one of the things that we want to make sure of also is to indicate that if they have been on temporary layoff, temporary leave, a temporary shutdown, that now they will not be eligible for unemployment benefits, and attendance policies will apply. We also need to help them understand what happens to their benefits. Benefits for those that were in March laid off may be ending April 30th. If we call you back to work before then, that's great. If we don't, we could be hitting a COBRA notice, a COBRA qualifying event. So helping them to understand by a return to work what's happening to their benefits. And at this point, it's also, I think, important for you to state what are some of the things that you are doing to protect the employee in the workplace. So what about your training on social distancing? What training do you have around personal protection equipment? What's going to be available to them? So some sort of summary that allows them to understand that you're taking all that into place should be part of this return to work notice. And then any opportunity for them to ask any questions. So I think that the return to work notice becomes pretty important to helping our employees understand what their responsibilities are and how the employer is taking responsibility for their provisions. So the next thing is, will they come back to work? We have both the fearful employees, we have the savvy employees, and so I want you folks to be thinking about both sides of that, both ends of that spectrum, sorry. When you think of the fearful employees, those who are making decisions that they want to stay out of the workplace because of an immunocompromised scenario, caring for an adult, another COVID-19 individual, whether it's an adult or a child. When you have a return to work notice, whether you have that category where the individual employee is not COVID-19 affected for them as an individual, but have another scenario where they may have been exposed or caring for somebody else. Now all the definitions of the leaves come into play because you've now asked them to come back to work. So now we have to have a very specific Q&A, communication, discussion with that employee to fully understand what their situation is. Is there any remote work? How are we making those decisions around remote work that might be available for an employee who does not want to return? And then we have the what I call the savvy employees. These are the ones I've already mentioned where you know, they are looking for, how do I utilize the full range of what's available to me under unemployment? How am I maybe taking the steps? I'm not saying this probably fairly. I'm looking at those employees who are saying I'm exposed, right? I had a conversation with my neighbor who had a COVID-19 symptoms, and now therefore I am needing to self-quarantine. Folks, all of this becomes, like I said, a Q&A, making sure that you understand what situation is with the employee, where is your responsibility as the employer to make a decision to bring them back into the workplace, and if they're not coming, what benefit are they eligible for, what documentation is required to support that. If you got to a situation where truly the documentation isn't there, they're refusing to come back to work, we have the unemployment reasons, qualifying reasons, I would at that point request that you don't go alone. talk with your legal counsel, make some decisions that are educated around how you're going to handle those particular circumstances. Right now, the default is all around protecting employees, protecting individuals from exposure to COVID-19. And we certainly want to make the right decision, but if we're choosing a discipline discharge, you know that there's a state order right now that prevents that. And so we want to make sure that we as an employer are also making educated decisions and making the right communication with the employee to protect and minimize the risk for some future claim. So this is going to be key. Having your policy well defined for the paid sick leave, having it well defined for the Emergency Family Medical Leave Act, actually having that put in a format that represents how you handle other policies. How are you going to maybe add a supplemental document or addendum to your handbook? What kinds of forms are you going to use to actually document this information? We have developed for a lot of our clients a very specific form that talks about what is the reason for which you're making the request, what documentation do you have. The law does require that the employees actually attest to a particular situation. So for example, I'm caring for my child whose primary, secondary school or place of care has been closed and is unavailable. Perfect. Child's ages, if 15 years or older, what are those special circumstances requiring me as the employee to provide care? And so how do you identify that? And then how do you have them testify that they are the only, attest that they are the only one available to provide care for that child. The other thing that's important, for example, is that there an intermittent work schedule that's available so that they can work on Monday, Wednesday, and Friday, but can't work Tuesdays and Thursdays. Or they can work a different part of the day and then be unavailable the balance of the day. So our recommendation is to have very clear forms available where you're documenting who's spoken to the employee, what documentation is coming back, how are your policies being written so that you can share those with the employees, and then you can walk through and keep those particular that particular information very well documented, not only folks for your tax credits, but also to back up that you took the interest of the employee into account and that you asked the appropriate questions and gather the information via an email or via some sort of written signed document that the employee attested that this was in fact the situation. You know, this is where now getting your definitions really clear for those that are dealing with employees. What does full-time mean? What is the definition of a child? I know that caring for a child, definition of a child, become what I would think some questions you wouldn't think you would need to ask, but unfortunately, I think it's important for us to understand what is our responsibilities. This slide really talks about what are some of the general information items you need to ask for under either one of the leaves. What are the healthcare related items that you would look for the employee to provide? And then, what if it's for yourself or whether it's caring for another individual? So we've identified here what some of the additional information is that it's necessary, and then I would actually gather that. I would put it with a particular form, making sure that that goes into your record keeping as a medical confidential file, easy access so you can handle it and have access. The last thing we're doing is really recommending that employers put together what we're calling a COVID-19 tracker. So what are they eligible for? What documentation did they provide? Was there remote work available? Did they actually request intermittent? What's the next point of return? What is the next point of contact, especially if they're under FMLA? So all these kinds of things would allow us to keep current and not have communications with the follow-up communications with the employees fall off the table. Job restoration, so really being clear, what is the scenario for those that may be out, getting yourselves up to date on for your particular company, for your the particular role, what are the job restoration responsibilities? Again, we talked about tax credits, making sure that we're very clear on what the documentation is that's necessary. This is a nice summary that we've put together. Our tax folks here at Raymond, where we have what happens for the paid sick leave credit, the family leave credit, the employee retention credit, if that's something the employer has gone after, and then the employer payroll tax deferral, which is all 4 different options for getting the actual tax credits. So this is one of the next things that I definitely wanted to take a moment on, and that is what happens when our employees are actually coming back to work, or even if we have an extended period where we might be doing partial schedules, reduced schedules. What happens in terms of any pay cuts? Are they temporary? Are they through the end of the year? Are they, what is the criteria for being defined when it might be reinstated? If there's any, is it any pay cut that's determined now is not going to be reimbursed, meaning there's not a rollback that it's going to come back to you later, right? What's happening with our medical benefits? And again, if they're out on work, when is the effective date for those benefits to end? So if we have folks that were out in March, and you're an insurance provider, said you had end of month plus 1 month, that means April 30th could become a qualifying event. So if that happens and we still haven't returned our employees to work, what happens when you do? If it's after April 30th, what does that mean? Do we, most insurance providers, but again, getting this clear, are allowing a no eligibility period again. You're actually able to bring them back. But being in good communication with your benefit broker and your insurance provider to understand how these policies are changing based on this extension of the COVID-19 impact. Where might short-term disability come into play, especially if employees that are out with extended health reasons, and how are you making sure that you're communicating and interplaying, integrating those particular policies that become important to an employee. 401k, a lot of information out there right now on how retirement plans are impacted, both from an employee point of view and an employer point of view. Discussion around hazard pay. All of these things, we're seeing employers continue to evolve around. There's questions about how can I provide some bonuses for employees who are coming back to work at the workplace. All kinds of small strategies, incentives that need to be well documented, beginning and end, qualification criteria. So this is an area where I think we need to not forget to spend some time on. One of the things that I think is also important for us to be aware of is how do our ERISA laws come into play? How do we make sure that when we're applying these kinds of changes that we are doing it consistently? We don't want to move into discriminatory practices, and so we want to make sure that we're again taking a look at are we applying these fairly and equally as our plans allow to all employees. I think the other piece of this that we don't want to forget is how do we keep our employees engaged? How do we keep the communication open with them? I know we've had many of our employers who are actually doing great communication around frequently asked questions around benefits, frequently asked questions about reminding us, why are we working? Why am I an essential service provider? What are the preparedness things we're doing? So keeping those things in front of employees, helping to educate them, encouraging our managers to reach out to employees on a one-to-one, doing what we're calling team huddles. I know we've had, here at Raymond, we've had several what we call happy hours, where we gather at the end of a day and just share some personal experiences and just really build that continued rapport, giving us a break from working at our, in my case, my dining room table from 6:30 to 7 every day, right? So what are you putting into place? How do you maybe engage things like the Gallup kind of surveys or pulse mechanisms so that you can get some input from employees in a very quick turnaround time on actions that you could be doing better or what their needs are. So I think there's lots of opportunities that we don't want to forget about using as we continue to bring our employees back to work and recognize that we're going to be into this scenario for a while. Okay, so wow, that was quite a bit of information I shared. Obviously, for each one of these areas, there could be a lot more detail, and I'm certainly happy to provide that for those of you that might have more specific questions. But Lori, I'm sure there's a couple questions.
Thank you. Great stuff. We appreciate you going through all that. So I'll pitch these two. If you don't know the answer to them, that's fine. I know some of these might be out of your domain. The first one is, does unemployment under the Michigan Work Share Program include the extra $600 as a flat amount in addition to the regular work share benefit?
My understanding is, and I'd like to confirm this, but under the work share program, you have a weekly benefit amount, and they just adjusted that down to a different percentage level of work. But I believe you're working, so I am not sure if the 600 is available or not. It's intended for those that are not working. So let me get back to you on that one specifically, Lori. And especially also, with the new order that just came out in the last day regarding the work share program and its expanded benefits.
And we are SPM is trying to get someone from the UIA office to come in and talk about work share. So we're getting a lot of questions that around that. So hopefully we'll have more for that. We're trying for next week. Next question. I'm a business owner with 15 employees and we've basically been closed due to the executive order. How do I go about getting the exemption for the EPSLA?
There is, at the last I checked, there was no formal documentation that had been identified. Now there is an IRS link, and certainly, Lori, I'll provide that to you.
Okay.
But the basic idea would be to answer the questions for how you fit. So what is your business viability? What happens, which employees are if not there, would create an issue for you to deliver services. So there's several criteria. It's mainly right now up to the employer to make that documentation and make that business case. There's no place at the very moment to forward that, but I will also provide the IRS link for further review of that.
Okay, this one is related similarly. Looks like unemployment covers a lot of the same reasons the EPSL and the EFML do. How would you determine which to use? I understand that EPSL and the EFML are required, so would you use those instead of using unemployment?
Well, no, it's very clear. If you have work for the employee to do and they meet one of the qualifying reasons, then they would fall for under one of those leaves, either the paid sick leave or the emergency family medical leave. If you do not have work and you are on a temporary shutdown, then you would not pay for the paid sick leave or the emergency family and medical leave act. So it's only when an employer is paying an employee that the leaves come into play. If you stop paying the employee, then unemployment comes into play and the leaves do not.
Okay, great. Switching subjects, what about those employees that are in a high-risk group that are self-isolating at employer groups of 500 employees or more and cannot work from home? I'm not sure what the question is here.
Well, in that particular case, one of the things we've asked our employees to do is seek medical guidance. So maybe there is a valid reason for why their healthcare provider would identify them to not be able to come to work. We've seen employees who are just recently recovered from a major surgery, for example, and their doctor says, yes, please do not return to the workplace. We want you to self-quarantine. Well, in that particular case, if you have a valid healthcare provider and there's a valid reason, now I would evaluate them under other company personal leaves of absence, vacation or PTO policies.
Susan, you had mentioned earlier there was a form that people could use, that documentation was an important part of this process. Would you be able to share that with our viewers as well?
You know, we've put that together as a customized tool for each one of our clients. We'd be happy to talk with you about your specific situation, but obviously we've invested a lot of resource and best practice into into developing those.
Okay, so but do know that's out there as a resource, folks, that there would be something that Raymond would be able to help you with. All right, there's a concern about the chargeable amount that's going back to employers. This person has received their determination letters, but it still has a chargeable amount in there to the employer. Any advice on that?
Oh, I see what you're saying. So what you're saying is on the form,
Yes.
form 1575 or on the unemployment, there could be an indication that the employer is being charged.
Mm-hmm. Probably the way it was set up. The system was not set up to not do that, but we're told that they won't be charged.
That's true. That's true. And one of the things I would make sure we're, again, there's a little bit of confusion. Did the actual reason for filing, did the employee indicate the right reason? So for example, they might have picked regular layoff and not a temporary layoff due to COVID-19 or related to COVID-19. So it's triggering different responses. It would be up to the employer and the employee to help go get that corrected. Okay. And then I believe you would see a reconciliation of those charges maybe after the fact. But if it's a COVID-19 related reason for which there is an application for unemployment, then there should not be a charge to the employer's account.
Okay. This one is somewhat similar. They had two employees voluntarily resign prior to the pandemic, but they continue to file and refile for unemployment benefits, claiming there was a temporary shutdown as the separation reason. Anything special the employer needs to do except respond that they voluntarily resigned?
You know, so this will go back to our documentation. So if you received an email from the employee that indicated they were voluntarily resigning or they were not returning to work because of some reason, and you had work available, that could be one area of documentation to provide to the unemployment in your response. if in fact you were on a temporary shutdown, and or it depends sort of on when the employee put in their notice, that could be dependent as well. But if it's truly a case of the employee voluntarily resigning when there was work available, then that there could be an opportunity for you to contest that application for unemployment benefit.
Okay, great. You know, and we have
one thing on that, Lori, even though, so this is the unique part, even though we may contest it, the actual decision for whether or not that benefit should be awarded is still with the state. The state may choose that this employee had a valid reason for quitting and still be eligible for the unemployment benefit. So unfortunately, that's where we do not have control, but our documentation and our response to the unemployment agency being very clear about that status could make the difference.
Great. And, you know, there are a few more questions in here that we haven't gotten to. Folks, I would encourage you to send those to sbam@sbam.org. We'll just take one last one. I know some of these we've covered before. This one was asking if the owner of a company less than 10 employees, are they exempt from the paid leave entitlements? Is a business with less than 10 employees exempt from paid leave entitlements?
There's a lot of questions there. Are you paid as an employee of the company? So that one would require a few more questions to give what I would be, feel good about being the right guidance. I think, and it could be, are you asking if you're exempt as the employer from providing the PSL versus am I able to use it myself? So again, a few more questions might allow me to, you know, provide the right guidance there.
Well, good. Well, I can't thank you enough, Susan, for presenting this to our members today. Again, a copy of the webinar and the slides will be on site. Absolutely. And special thanks to Samantha Breggy for running the slides for us today. Really appreciate you being here, and thanks for all you guys are doing.
Oh, you're welcome, Lori. Thank you, everybody.
Have a great day, all. Bye.